Hello, my name is Cleveland Simmons. I'm an associate at Secrest Wardle in our Troy office. Today I will be presenting a webinar about liability for animal attacks. The main purpose of this webinar is to provide context to landowner, property owner, and landlords in premise liability situations. While we typically think of animal liability in terms of the animal's owner, in certain instances, a plaintiff may also be able to recover from a landowner even when the landowner is not the same person as the owner of the animal. Knowing the difference between the types of animal attack lawsuits is important for tendering a proper and appropriate defense. In Michigan, liability for animal attacks can be split into two categories: common law theories of liability for animal attacks and statutory strict liability for dog bites. Under Michigan's common law, there are three theories for recovering damages in a civil lawsuit for animal attacks. These theories are strict liability, negligence, and common law liability for landowners. We will first discuss the difference between these common law theories. Common law strict liability applies only to the owner or keeper of a domestic animal. Generally, domestic animals are dogs, cats, and birds. However, pigs, cows, horses, chickens, and other animals have been considered domestic animals when they have a specific and extensive relationship with their human owner outside of the usual situations we typically envision these animals in. For example, we generally see pigs on farms and being raised to become some type of pork product, such as ribs, bacon, ham, etc. However, there are some people who keep pigs as pets in their home. In these situations, if the pig bites someone, common law strict liability will be at play. Now, under common law strict liability, the owner or keeper of a domestic animal is liable for damages caused by that animal when the owner or keeper knew or should have known of the animal's dangerous or vicious propensities. This definition comes from the seminal Michigan Supreme Court case Traeger versus Thor. As you can see, there are several elements to a common law strict liability claim. The easiest element to spot is ownership. Obviously, if you are the owner of an animal and there's no dispute about your ownership, then you will be strictly liable for that animal's bites or attacks, assuming the knowledge requirement can be established. We will get into the specifics of the knowledge requirement in a later slide. However, what if you're not the owner of the animal? Then under common law strict liability, we must determine if you are the keeper of the animal. Notably, a temporary custodian, caretaker, or babysitter is not considered a keeper of the animal for common law strict liability purposes. As the Michigan Supreme Court in Traeger ruled, a temporary caretaker has no choice regarding whether the dangers an animal presents will be introduced into the community, nor have they agreed to shoulder responsibility for injuries that animal might inflict. Basically, if you're just temporarily watching someone's domestic animal, you will not be strictly liable for that animal's attacks. However, you may be liable under other common law theories, which we will discuss later. The most important element of a common law strict liability case is whether the owner or keeper knew or should have known of the dangers the animal poses. We have all read articles or heard stories about pit bulls attacking people. However, in Michigan, dog breed simply does not matter. In fact, in an unpublished but very persuasive Michigan Court of Appeals case, Stacy v. Colonial Acres, the Michigan Court of Appeals specifically ruled that pit bulls are not categorically dangerous under Michigan law. Therefore, even with pit bulls, common law strict liability only attaches where the owner or keeper knew or should have known of that particular dog's vicious propensities. Additionally, in a published Michigan Court of Appeals case, Taylor v. Mobley, the panel upheld the trial court's evidentiary ruling that the dog breed, a pit bull, was irrelevant to the issue of damages and more prejudicial than probative. The Taylor case presents a good example of a situation when a specific pretrial motion in limine should be used to keep such prejudicial information, such as dog breed, from getting to the jury. The question you must be asking yourself now is, if breed is not relevant, then what about an animal's history of previous bites? Is a history of previous bites conclusive of evidence of viciousness sufficient to satisfy the requirements of common law strict liability? The answer is not so straightforward, but it does provide some guidance. In Veal v. Spencer, the Court of Appeals ruled evidence of previous bites is relevant in determining whether the owner or keeper knew or should have known of the animal's violent propensities. However, the mere fact that an animal has bitten or attacked someone in the past is not evidence that the animal should be considered vicious as a matter of law. Therefore, prior attacks will be taken into account, but it's going to come down to what the owner or keeper knew or should have known about that particular animal. Similarly, normal animal behavior is not evidence of dangerousness. For example, dogs bark, growl, and jump on people. This is all normal dog behavior and will not be admissible to prove viciousness. To conclude, knowledge of an animal's alleged dangers is something that will be determined on a case-by-case basis. The fact that a dog breed is generally viewed as dangerous, i.e. pit bulls, does not matter. What matters is, did the owner or keeper know that that specific animal was dangerous? As discussed above, common law strict liability applies to domesticated animals. Specifically, some people could keep equine animals like horses, mules, donkeys as pets. In fact, there was actually a reality show about a skater, his bodyguard, best friend, and their mini horse that aired for several years. In their case, and if they lived in Michigan, they could be potentially liable under common law strict liability if that domesticated mini horse bit someone and they knew or should have known the mini horse was dangerous. However, in most typical equine situations, there is immunity for equine animal attacks. The Michigan legislature enacted the Equine Activity Liability Act, which grants immunity from tort liability in situations where the owner is an equine professional for compensation and the participant sustains an injury as a result of the inherent risk of equine activity. The Michigan Court of Appeals has a rule that even those visiting, touring, or using equine facilities or stables are considered participants under the EALA. Additionally, equine professionals must post and maintain conspicuous, no less than 1 inch in height warning signs in the area where the equine animal is kept. Now we will get into common law negligence for animal attacks. Generally, negligence in Michigan is simply stated as duty, breach of duty, and causation. However, in the animal liability context, it must also be established that the owner, keeper, or temporary caretaker knew or should have known of the animal's dangerous propensities. Notice the difference between strict liability and negligence for animal attacks. In common law negligence cases, even a temporary keeper can be negligent for an animal attack. Also note that the protections of the EALA will not apply to an equine animal attack when the owner is negligent. Under Michigan law, dogs are generally regarded as so unlikely to do substantial harm that their owners or keepers have no duty to keep them under constant control. The mere failure to do so does not constitute an automatic breach of any duty. However, when the animal's dangerous propensities are known or should be known by the owner, keeper, or temporary babysitter, then there is a duty to keep that animal under control. Even so, in situations where there is no knowledge of the animal's dangerous propensities, the owner, keeper, or temporary caretaker can still be negligent for failing to restrain the animal or prevent harm caused by that animal. Again, just like in common law strict liability cases, in the common law negligence aspect, normal animal traits are not conclusive evidence of dangerousness. For example, in Kinney v. Crane, an unpublished Court of Appeals opinion, plaintiffs were jogging past defendant's home when defendant's son let out the adult dog. The dog ran towards plaintiffs, jumped on its hind legs, and placed its front paws on one of the plaintiff's shoulders. She fell backwards but was caught by her husband before hitting the ground. The dog then began to circle the plaintiffs. However, the dog never barked, snarled, growled, or bit either of the plaintiffs. Plaintiff alleged an aggravation of her previous back injuries and scratches, none of which broke the skin, though. Eventually, the Kinney court found that there was no breach of any duty owed to the plaintiffs because no reasonable juror could conclude that the defendants were negligent for normal dog behavior that was neither aggressive nor vicious. Plus, the dog had no history of aggressive behavior. The Kinney case reaffirms that normal dog traits are simply not enough to establish that a dog is dangerous or vicious. In these common law situations, a carefully crafted motion for summary disposition should always be considered because plaintiffs can plead multiple theories of liability in one case. For example, maybe you're just a temporary babysitter of a dog that bites someone. Plaintiff files a suit against you, but plaintiff pleads common law strict liability and negligence. If you never knew the dog was dangerous and had no reason to know, then a motion for summary disposition should be filed on the entire lawsuit. However, if you had some knowledge of the dog's dangers, but you're not the keeper of the dog, then moving to dismiss the strict liability claim is the way to go. Narrowing the issues is always an important strategy, even if some of the claims will remain after your motion. Now we will discuss how landowners, property owners, and landlords can be liable for animal attacks. Obviously, if the landowner is the owner, keeper, or temporary keeper of an animal, then one or both of common law strict liability or common law negligence will apply in addition to claims typically reserved for landowners only. However, the more difficult fact patterns include those cases where the landowner leases or rents the property to a tenant and that tenant's animal attacks someone. There are two theories for landowner liability in these situations: negligence and premise liability. We will discuss negligence first. The same elements as discussed in the previous slides will apply here. Negligence in Michigan is simply duty, breach, causation. However, the more pressing question is, when is a duty imposed on a landowner? Similar to common law negligence for owners and keepers, a duty is only imposed on the landowner for an attack by a tenant's animal when the landowner knows or should know of the animal's dangerous propensities. However, it is important to note that the mere failure to enforce rules regarding dog breed or size does not by itself create a tort duty on the part of the landlord. For example, in Braun versus York Properties, a 12-year-old child was seriously injured when bitten by his neighbor's dog, a Labrador, while playing inside the neighbor's mobile home. Plaintiff, along with his parents and brother, commenced a lawsuit against his neighbors and the property owners. They specifically alleged that the property owners were negligent for failing to enforce rules and regulations about dog breed and size. Plaintiff won at the trial level, but on appeal, the Michigan Court of Appeals held that the mere failure to enforce rules does not create a separate duty for the landowner. Instead, the court looked to a non-exhaustive list of factors to determine if a duty should be imposed against the landowner. In the end, it all simply boiled down to whether the landowner knew the specific dog was dangerous. There was no evidence the landowner knew that specific dog was dangerous, so the trial court judgment was overturned. Another issue that comes up relative to a landowner's tenant is, does a landowner have a duty to protect third parties off premises? Generally, the answer is no. Landowners do not owe a duty to protect third parties from attacks by a tenant's animal that takes place off of the leased premises, especially when the animal was acquired after the premises were leased. However, a landowner may be liable for off-premises attacks when the landowner knows or should know of the dangers the animal poses. Another issue that comes up is the duty to inspect the premises. After the premises are leased, there is no separate duty for the landowner to inspect the property to discover the existence of a tenant's dangerous animal. However, when the landowner knows or should know of the animal's dangerous propensities, negligence will attach if the landowner does nothing and then the animal attacks someone. In these circumstances, the logic is obvious. If one tenant tells the landowner that another tenant has a pack of dangerous dogs and the landowner does nothing to rectify that situation, and later those dogs escape the property and bite someone or bite someone on the property, then there's a good chance that the landowner will be held liable under a negligence standard for failing to do anything about the dangerous dogs. The other way landowners are liable for animal attacks is in premise liability cases. In premises liability actions, there is a potential liability when a condition on the land causes damages or injuries. Therefore, in a premises liability action, the question is, can an animal be a condition on the land? In the Clement case, a loose, unsupervised dog, either on the property owner's land or in close proximity, without a fence preventing the dog from entering the adjacent land, was considered a condition on the land within the meaning of a premises liability action. A key to that decision was the fact that the property owner was aware of the dog's prior bites. The court found that the property owner owed a duty to exercise reasonable or ordinary care to prevent injury to a child social guest because he was aware of the dog's prior bites. As we can see, even in situations where an animal may be deemed a condition on the land, it still must be proven that the landowner knew or should have known of the animal's dangerous propensities. The other theory in Michigan is statutory liability for dog bites. The dog bite statute is exactly that, liability for dog bites only. Contrary to popular belief, dogs do not get one free bite in Michigan. The dog bite statute is codified in MCL 287.351. The dog bite statute imposes almost absolute liability on the owner of a dog. In relevant part, the Michigan dog bite statute states, if a dog bites a person without provocation while the person is on public property or lawfully on private property, including property of the owner of the owner of the dog shall be liable for damages suffered by the person bitten, regardless of the former viciousness of the dog or the owner's knowledge of such viciousness. As we can see, viciousness of the dog or the owner's knowledge of the dog's viciousness simply does not matter in a statutory cause of action. This is a significant divergence from the common law theories we previously discussed. Dog bite victims often try to impose statutory liability on property owners when the dog is owned by a tenant. However, Michigan courts have rejected this argument on several occasions. Similarly, a temporary caretaker or keeper cannot, as a matter of law, be considered the dog's owner within the meaning of the dog bite statute. For example, in Foster, an unpublished Michigan Court of Appeals case, a deputy sheriff was responsible for possessing and maintaining a law enforcement dog 24/7, regardless of whether he was off duty, on vacation, or outside the county. While off duty, the deputy took the dog to a cottage where it eventually bit someone. Regarding the claims under the dog bite statute, the court found that even in light of the deputy's possession, control, and care of the dog, he was not an owner under the statute because the dog ultimately belonged to the county. Therefore, even in situations where there is 24/7 possession and control and care of the dog, that will not automatically make a person an owner under the dog bite statute. Therefore, ownership must be actual. It cannot just be perceived. Now we will discuss defenses to animal attack lawsuits. In common law actions, including strict liability, negligence, and premise liability, a landowner does not owe any duty to a trespasser except to refrain from injuring the trespasser by willful and wanton conduct. Basically, you can't set a trap to induce someone to come onto your property and get bit by a dog. In this case, the trespass defense simply won't work. Additionally, under the dog bite statute, a trespasser is not entitled to any recovery. A dog bite victim under the statute must show that he was an invitee or licensee in order to be protected by the dog bite statute. Here are some examples. In Cummings v. Gertman, an unpublished Michigan Court of Appeals case, plaintiff was bitten by defendant's dog while he was in his niece's backyard, which is adjacent to the defendant's yard. The properties were separated by a fence, and at some point, plaintiff asked one of the defendants if the dog bites, and he was told that it has never bitten anyone. Next, plaintiff placed his hand on the fence with a portion of his hand extending into the defendant's yard, and the dog bit him. Ultimately, the court concluded that plaintiff was a trespasser on defendant's private property when he placed his hand on the fence without permission and a portion of it extended into their yard. Therefore, even a slight or incidental trespass into property is enough to trigger the trespass defense in a dog bite case. In Kelsey v. Lent, the court ruled that plaintiff was not a trespasser when returning to defendant's property after a garage sale. Plaintiff had an implied license to enter the property based on an implied license to approach a residential home and knock on the door. Absent fencing or a no trespassing sign, plaintiff still was within the scope of the public's implied license when she exited her vehicle and was attacked by the property owner's dog. There is an absolute defense to claims brought under the dog bite statute when the victim provokes the dog. Typically, we think of provocation as an intentional act. For example, if a random person hits a dog with a stick for no reason and then that dog bites that person, the defense of provocation will prevent that person from filing a dog bite lawsuit. However, unintentional acts can also satisfy this defense as well. In Brands v. Ekstrom, plaintiff unintentionally stepped on the dog's tail and was bit in the leg. The court looked at the definition of provocation and found that the intent of the victim is not relevant to determining whether there was provocation. Additionally, some intentional acts are not provocation. In Coivisto v. Davis, defendant's dogs escaped, entered plaintiff's property, and attacked her cats. In response, plaintiff stuck her fingers in one dog's eye and kicked the other dogs. The dogs eventually attacked the plaintiff. The court held that plaintiff's intentional acts did not constitute provocation under the statute because the dogs were already in an aggressive and violent state before plaintiff made any contact with them. In an action based on tort or any legal theory seeking damages for personal injury, including common law claims, the plaintiff's award of economic damages must be reduced by the percentage of fault allocated to the plaintiff. For example, if plaintiff is claiming lost wages as a result of a dog attack under any common law theory, and there is evidence of provocation or some fault attributable to the victim, then the defendant can specifically ask the jury to allocate some amount of fault against the plaintiff, which will reduce his economic award. On the other hand, if plaintiff is deemed to be more than 50% at fault for the animal attack, then his non-economic damages, pain and suffering damages, will not be awarded. Michigan's Comparative Fault statute can be found at MCL 600.2959. Unfortunately, comparative fault is not considered in a statutory dog bite action. If there is provocation or trespass, then there are absolute defenses. But anything short of that is insufficient to relieve a owner of liability under the statute. Just a few practice notes before we wrap up. Evidence of prior good or bad behavior on the part of the dog is not admissible nor relevant in a statutory dog bite action. Such evidence is also irrelevant to a finding of liability under the statute. Also, a plaintiff can present statutory and common law claims in one case. Here are a few takeaways relative to a landowner's liability in the premises liability context. If you are a landowner and the dog owner, you will be subject to common law and statutory claims. Landowners can be liable for their tenant's animal, but they must know or should know of the animal's dangerous propensities. Dog breed does not matter regardless of the type of case. A carefully crafted pretrial motion in limine on the issue of dog breed must be filed, especially if the dog breed involved in the case is one that is generally seen as dangerous in the eye of the public. You simply cannot let this information get to the jury because it will be more prejudicial than probative. A landowner's failure to enforce rules about dog breed and size is not a breach of any duty. Again, it will come back to what the landowner knew or should have known about that specific animal. Because a plaintiff can plead multiple theories in one case, it is important to carefully examine the plaintiff's complaint and move for summary disposition on any and all claims that can be dismissed. The more claims that can be presented, the better chance that the plaintiff will get a large recovery at trial. Therefore, it is always important to narrow the issues as much as possible before proceeding to trial. Thank you for listening to this webinar on liability for animal attacks. If you have any questions or want any more materials on this subject, feel free to contact me at your convenience.